All right. Hello, everybody, and welcome. My name is TJ Scott. I'm an estate planning attorney with the law office of Timothy J. Scott, and I am presenting here tonight on estate planning matters. Um, let's see, I've lost control of my presentation. Here we go. All right, we're back. So thank you, everybody, for joining me. It is 7 o'clock. We're kicking off here, and I want to encourage you to turn off any distractions. If you have another tab open, I understand it might feel like we can multitask, but I really encourage you to give me your attention here tonight, and give yourself the time that you've set aside to learn about estate planning and especially about how estate planning matters are important or certain considerations that you want to give as a Catholic, if you are Catholic, to estate planning matters. There's going to be material here for everybody. We're not just picking on Catholics here tonight, but there are some certain special things that Catholics are going to want to consider. I always tell people your future self will be glad that you took the time, and that you gave yourself the time that you've set aside here to be with me tonight. Um, I want you to stay with me all the way through the end. We have a lot of material to go through, so I'm going to be moving pretty quickly as we go through this, but I want you to bring your questions. I've already had a number of questions in the chat. I don't think I've seen anything come through from the Q&A, but I will be monitoring that as well here tonight. And I want you to bring your questions and get answers to your questions. That's a fantastic part of this presentation tonight is you have live a real Minnesota estate planning attorney that you can ask your questions of. I help people with probate, I help people with estate planning, and I'm here to answer your questions. So please bring me your questions and stay with me here. I have lots of information to share. If you stay with me all the way to the end, I'll tell you how you can get a free virtual one-on-one meeting with me, so that we can talk about the things that you have and the people that you love and how you can protect them. Plus, we're going to talk about a bonus gift that I want to give you to make it even easier to get a custom tailored estate plan in place to take care of the people that you love. But you got to stay with me until the end in order to find all that information out. I'm curious, what are people hoping to learn here? And if you want to go ahead and share with me either in the chat or in the Q&A section, we've already had some questions coming through that are fantastic, but go ahead and share with me either in the chat or the Q&A so that I know exactly what it is that you're hoping to learn here. Maybe you've done a do-it-yourself will or an online will, and you want to know if that's going to be sufficient to take care of the people that you love. Or maybe you did an estate plan, but it's old and it names guardians for people who no longer need guardians named for them. Now you want to know if that estate plan is still good or if it needs to be updated. We'll talk about how often you should look to update your estate plan. Or maybe you just want to have a better understanding of a plan that you've done or estate planning in general. And you're hoping that I'm going to have some answers for you here today. I see somebody saying we are just beginning, and I completely understand. I see somebody else sharing trust or transfer on death deed, and that's definitely something that we're going to address here tonight. A lot of people, sometimes people have an estate plan in place when they come and talk to me the first time, or more often, people don't have an estate plan in place and they are just beginning, or they have such a rudimentary estate plan that we're looking to kind of begin again. And there are opportunities to do that, and we'll certainly do that. We'll talk about those things here tonight. Preparing for the possibility of long-term care challenges. Yeah, absolutely. That's a really tough one. And we'll talk a little bit about nursing home care and kind of what you can do to protect your assets. But it's a tricky conversation, and it's really a conversation that's very fact specific. And so I really encourage you to reach out if you have that type of a question after our presentation here today, and schedule some time with me. I see someone else saying, I have some financial setup with beneficiaries. I've done nothing with property. Yeah, and that's good work that you've done so far, but there is a little bit more to do, and we can help you with that, and we can help to make it really simple. Those beneficiary designations are fantastic. They go a long way. Making sure that you have things jointly if you're married with a spouse is really important. But there are some additional steps that we recommend, and some additional things that we really recommend that you do. I'm seeing also differences between revocable and irrevocable trusts. And we will probably touch on that a little bit today. There are so many different types of irrevocable trusts. They're a great estate planning tool depending on what you're trying to do. We're going to be focused a little bit more on revocable trusts here today, and or what I often call a living trust. But we we might at least get into at least that point of what's the difference between a revocable trust and an irrevocable trust. Options for giving to your church as part of your estate planning. I love that. I love that spirit. Um, and absolutely, we'll talk about that and about how things default. So these are fantastic questions, fantastic suggestions about where this conversation is going to go. And we are going to cover a lot of those topics. And I will try to give some special attention to those topics that you've talked about. If we've gotten towards the end of the presentation and I haven't discussed them yet, I hope that you'll bring them back up so that we can talk a little bit more about them as well. I also see somebody sharing, you want to know what's needed to get started with a will or estate plan, and how to know if a will, trust, or beneficiary is best to use. And that's a fantastic question. Oftentimes, it's a really fact-based situation. It's based specifically on what your situation is and your reality, including what assets we're talking about and what family members or friends or loved ones or charities we're talking about. But we will talk a little bit about that. I just encourage you to reach out after our presentation here today so that we can get a little bit more specific about your situation. Great question. Here are some of the things that we're going to talk about today. We're going to talk about what is an estate plan. We're going to talk about healthcare decisions and how you can control the healthcare decisions that are made on your behalf. We're also going to talk about guardianship for minor children and how you can get that in place. It's especially important if you have minor children to get some kind of estate planning in place to make sure that they're taken care of. We're going to also talk about avoiding court and conflict if something happens to you. And we'll talk about that in the context of the court processes of guardianship and conservatorship, as well as the court process called probate as well. We're also going to talk about how you can control who receives and who would receive by default if something happens to you. All these are important things to talk about and important considerations as Catholics to make sure that we have the way that we want it to be. I see some other questions coming through. How do I make things easy for my family after I'm gone? That's fantastic. Let's pay a special attention to the avoiding court and conflict provision then, because that's a really important thing that we're going to be talking about a lot today. And then I see someone else sharing our house is paid up. How do I leave it to 3 kids without it going through probate? And there's some great opportunities for that. We can talk about things like a transfer on death deed or a trust. So pay a special attention as we start talking about living trust, especially with 3 kids. I typically avoid a transfer on death deed, but we'll talk more about how you can pass your property to your kids if anything happens to you. These are all fantastic questions. And tonight is a special night because a lot of times when I'm doing these estate planning presentations, I don't get to apply a special Catholic lens, but I am Catholic and it's important to me. And so I know as a Catholic, a lot of times we have questions about our values and how we can make sure that our values are carried through. So the special Catholic lens that I'm going to be applying tonight kind of comes from this perspective, thinking about the great commandments. Love God with your whole heart, soul, and mind, and love your neighbor as yourself. That these are the great commandments that we're called to. We as Catholics believe in a special respect for life, and we're going to talk about exactly what that means as we plan our estate here tonight. We're going to be talking about the responsibilities that we have as human beings, but also that we recognize as Catholics to God, family, and community. We're going to talk about how we can use estate plans to foster a growth in virtue with a special emphasis on looking at the Beatitudes as as a guide for how to grow in virtue. And we're also going to talk about striving for sainthood. And this is something that I think about a lot with my own little family. And so this is my family. That's my wife, Tobin. We have 5 kids. We live in Bloomington, Minnesota. Our oldest, his name is Ben. And then we have Elizabeth, who is on my left side in the picture, or my right side, I guess, as you're looking at your screen. Margaret, who's in front of her mother there. Little Bridget in the front, and I have George in my arms. So George just turned 1 really recently. He is walking now. He's a little cruiser and getting into all kinds of trouble. But I often think about sainthood when I think about my kids because that's my goal for them. That's really what my desire is for them and what I want for them. And so, what can I do as a parent to ensure that they have an easier path to sainthood? Is it making sure that they have received a large chunk of money at the age of 18 and never have to work? Maybe, but probably not, right? That there are other things that we're looking to do. So this is my family. We are parishioners at Holy Family Church in St. Louis Park. We don't have the kids in school. We actually homeschool our kids, and we're part of a great homeschool community there in St. Louis Park. And I actually see some people joining here tonight that are part of that community. So it's great to see you on the call here tonight. Um, a little bit about me. I graduated from the University of St. Thomas School of Law in 2012. I worked really hard in law school. I graduated near the top of my class, magna cum laude. It was on law review, things that typically set you up for a job in big law, like one of the big law firms downtown. But something spectacular happened to me the day after I commenced from law school, and that is that my son was born. And here you can see a picture of Ben on his first day in the world. Seeing Ben and being with my wife in that hospital room kind of clarified some things for me that I wanted to work in law in an area that serves people. I wanted to take care of people and really have a strong attachment to the people that I was serving. And I wanted to give value with my law degree to the people that I was taking care of. I was really lucky that I found an estate planning law firm in Minneapolis, or really actually here in Bloomington, close by where I'm practicing right now, where I was working under an estate planning attorney who had been writing estate plans for something like 35 or 40 years. That she was 70 something years old. She was kind of at the end of her career. I was just starting my career, and I was able to learn from her how to write really great estate planning documents. I also learned that estate planning documents are well and good, but the real advantage of working with an attorney isn't found within the four corners of the document. It's really making sure that you get the value from your estate plan and having a trusted counselor that you can go to and ask questions of to make sure that your estate plan is going to work the way that you want it to. And we'll talk about that here a little bit more as we talk. I see somebody sharing here in the chat, other Christian denominations believe very similar to Catholics, and I think that's good. I love to hear that. Yes, absolutely. We are Christians, and we have a lot of shared values and shared wishes for our family. So let me start with this. What is an estate plan? And I define an estate plan pretty broadly, that an estate plan is a plan for your person, your assets, and those you care about in the case that you become incapacitated or for when you pass away. And that's a reality that someday all of us are going to pass away. Some of us may become incapacitated before we pass away, but it's a reality. And as Catholics here, we can say memento mori, because we all have this understanding that yes, someday we will die. It's an inevitability, but it's an inevitability that we can plan for and that we can take care of it. And by planning for it, we're really providing a gift to the people that we love in order to make sure that they're well cared for. So I'm going to ask a question here. I'm actually going to share up a poll. Let's see if I can get this working quickly. And the question is, do you have an estate plan? And so if you don't mind sharing with me, it's just a yes or no question. I'm curious out of the number of people that we have here, how many people have an estate plan right now? And I'm seeing most people are saying no, they do not have an estate plan. At least of the people who have responded so far. We have almost 25 people able to respond. There are other people who've joined in other ways that don't allow them to respond. But I'm seeing, something like 75%, about three quarters don't have an estate plan in place right now, and about a quarter of us do. And what I have seen, the numbers that I have seen, that kind of bears out. There's something like 70% of Americans have not written a will in their lifetime. And so what I'm seeing from those numbers of the people who are willing to participate and answer that poll seems like we have a pretty representative sample of the American populace here today. The reality is we actually all have an uh, estate plan in place. I see here somebody is saying that they're stuck in the waiting room. I actually I don't think there's access to, I don't think there is a waiting room. So I would just tell that person to rejoin if somebody's hearing that somebody's stuck in the waiting room. please just have that person rejoin. Um, and I say we all have an estate plan in place because even if we haven't written an estate plan, the state has kind of written an estate plan for us. So these are some estate planning tools that you may be familiar with. They're just tools. They're resources that we can use to help plan an estate, things like a trust, a will, a healthcare directive, a power of attorney, memorial instructions that details what happens with your body after you're gone, things like beneficiary designations. I know somebody mentioned earlier that they have beneficiary designations in place, but they haven't done anything to deal with their property. And that's pretty common that a lot of people start their estate planning journey with writing beneficiary designations on things like their retirement accounts or their life insurance. I also see guardianship nominations. If you have minor kids, it's especially important to have those guardianship nominations in place and to make sure that you've detailed who's going to receive the kids if anything happens to you, where those kids are going to thrive until the age of 18. The reality is, again, that we all have an estate plan in place. Minnesota has written an estate plan for us, and that estate plan largely involves court. And that's true for things like healthcare decisions. That if we haven't made healthcare decisions on our own, and there's a dispute about what kinds of healthcare decisions we want to have made on our behalf, there's a court process that happens called guardianship to decide who gets to make those decisions and what those decisions look like. Excuse me for taking a drink there. Okay. Um, and you may have heard of guardianship before, or you may have heard of this individual before. This is a picture of Terry Schiavo. And Terry Schiavo was a young woman who suffered a cardiac event when she was young, and she was left in a vegetative state, and she needed to be provided for on a feeding tube. There was a dispute in the family. The husband wanted to remove the feeding tube, but her parents wanted to keep that feeding tube in and sustain her life. Ultimately, through a series of court cases, it went all the way up, even to a petition to the Supreme Court, when it was finally decided that the husband had the right to say what was going to happen with Terry. The feeding tube was removed, and Terry passed away about 2 weeks after that feeding tube was removed. So Terry's case is, from the early 2000s, mid 2000s, was a wake up call to a lot of us about matters of life and matters of making decisions and having autonomy over our own healthcare decisions. And we can have autonomy over our healthcare decisions by writing what's called a healthcare directive. And in a healthcare directive, we do two things. Number one, we name agents who would make healthcare decisions for us if we couldn't make those decisions ourselves. And number two, we talk about what wishes we would want to have made, what provision for the care of our life and for life-sustaining treatment we would want carried out if we couldn't make those decisions. And as Minnesotans, we have access to a fantastic resource, especially, for us Minnesota Catholics. We have access to a Minnesota Catholic Healthcare Directive written by the Minnesota Catholic Conference. And actually, it's approved by the Minnesota Catholic Conference of Catholic Bishops. I think it's actually based on a form that's put out by the USCCB. In fact, this is a fantastic resource that we have that has some special provisions as Catholics in it. Things like we believe that life is a precious gift from God and that we want to receive spiritual support if we're in a time of health crisis. We want our friends and our family and our faith community to pray for us. And we want access for a priest in order to come and see us. That we want to receive ordinary and proportionate care, but extraordinary care can be tried for a time and then stopped. It doesn't have to necessarily be continued. However, medically assisted nutrition and hydration, things like a feeding tube and tube hydration, are typically considered ordinary and proportionate care as long as the body is able to absorb those nutrients and adjust to those nutrients. And the reason for that is if we remove a feeding tube, if we remove tube hydration, and death follows from that decision, then we're really causing that death by dehydrating the person or starving the person. And as Catholics, we have a strong, there's a strong doctrine to not permit that, to not allow people to starve or to dehydrate to death. In that healthcare directive, the Catholic healthcare directive, it also says that pain relieving medicine is fine as long as it's not administered for the purpose of hastening our death. And so that's we can absolutely, we don't have to suffer through the pain as Catholics, but that the purpose of administering that uh, that pain medicine has to be for the right purpose. It has to be to make sure that we're not suffering, not to hasten our death. And that pregnancy is, there are some special provisions for pregnancy to preserve unborn life if in case that the mother is pregnant before she passes away. As Catholics, there are also some special provisions that we typically want regarding the disposition of our remains. For one thing, there's something called an apostolic blessing that removes even the temporal punishment for sin if we're able to receive that apostolic blessing before our death. And a priest can deliver that apostolic blessing. It's a beautiful prayer, and it's something that I hope that we all are able to receive before we pass away. We also have some provisions about, or we also have some teaching about organ donation. The church teaches that organ donation is a great gift, but also that it must be done at the right time. And the right time is a little bit difficult to pin down. There are some thoughts on brain death and whether that is actually true death, and also on things like donating hearts and lungs and the complexities involved with those types of donations, whether it actually causes the death of the person when that donation is made. So there are just some special considerations that we have there as Catholics, things that we discuss often in the estate planning meetings that we do. The church prefers that there be a mass, a funeral mass, with the body present for a last visitation. Here in Minnesota, because of some special provisions that we have in the law, embalming is typically required in order to make sure that the mass is actually available for that, or that the body's actually available for that mass, which means oftentimes that if a cremation is going to happen, the body just isn't going to be present. I think over 3/4, somebody I just heard somebody recently saying something like over 3/4 of Catholic funerals, the body isn't present because the cremation has already occurred. And that's okay. It's not preferred, but the church understands that it can't always, the body can't always be present at the funeral mass. And so cremation is okay. And cremation versus intact burial, cremation has been okay in the church going on, something like 70 years, something like that. It wasn't always permitted in the Catholic Church, but now it has become acceptable, and the church does teach that it's okay as long as the ashes are treated, the cremains are treated in a respectful way. So the church teaches that we ought not be spreading ashes or tossing ashes in the wind, and that really the ashes should be buried or put into a niche in consecrated ground after that death and after that cremation. I see somebody sharing, I've been to funerals with the body present and later cremated. Is this accepted? And yes, it is. Actually, that's the preference of the church, is that the body be present at the funeral and then cremated after the showing and after there's been time for that last goodbye. And also a Gregorian Mass series isn't required, but it's a nice devotion. A Gregorian Mass series is a series of 30 masses that is said as close in time as possible to the death of the individual. And it's just a beautiful devotion. It's a beautiful tradition, and something that a lot of my clients opt into if they have decided or if they care about that after they pass away. All right. So there are some Catholic considerations that we've made. We'll continue talking about Catholic considerations throughout, but especially on those healthcare issues and on those issues of what happens with our body after we're gone. It's really important that we make sure that we understand what the Catholic Church teaches, and that if that's something that we value, that we carry out those wishes that way. When we talk about guardianship, we're talking about one of the most important, one of the most precious things that we have, and that's our minor children. children under the age of 18 and making sure that they're cared for well in case anything happens to us. And if we haven't made elections about where those kids should go, then the default is that a judge is going to get to choose where those kids are going to go. And that decision is made in the best interests of the child. But oftentimes we know what the best interests of our kids are. And we are really the best person to make those judgments and to make those decisions. But if we're leaving it up to a judge, they're just going to use their best efforts to make those decisions. And that's true for long-term guardianship. Long-term guardianship is who's going to raise the kids until the age of 18 until they're ready to be out on their own. And I always joke, if you know that Uncle Larry is definitely not the right person to raise the kids, or Aunt Cindy isn't the right person to raise the kids. No offense to any Larrys or Cindys that are on here, but a lot of times we know who the right person is to take care of our kids, and we know who would be totally unacceptable. And unless we've done something to put those wishes down, then this is what the judge is going to look at. And here you can see that there are some special carve-outs for spiritual considerations, but they're pretty minimal. And there are a lot of considerations that are given greater weight and greater authority to where those kids are going to go if anything happens to the parents. For short-term guardianship would be if you didn't come home from a date night, for example, and the babysitter was there with the kids and it's taking longer and longer, and eventually the babysitter calls the police and they show up to the house. Who has the legal right to stay with those kids until the long-term guardians are appointed? And if we don't have documentation in place, oftentimes this can be a gray zone where foster care or child protective services might need to be called in for a time in order to take the kids, but that's not ideal. As for me, I don't want my kids to have to go and spend any time with child protective services or in the foster care system. And so this is a really important consideration that we make sure that there's somebody who's legally entitled to stay with the kids, that they don't need to go into child protective services or foster care. See somebody sharing, I assume a guardian can be changed at any time to another family member if needed. Also, should other family members know this prior example, so grandparents don't try to fight it, especially if moving out of state. And yes, this is a really fantastic, you've got some really fantastic elements that you're considering here. Yes, guardianship nominations can be changed at any time. You just need to work to get those documents updated and recertified, or executed properly. Um, and it can be challenging whether you want to share this information with family or not, especially if things may change in the future. However, having it written down will be the best thing that you can do to ensure that there isn't a fight. That if you have nothing written down, if nothing is legally documented, then you really risk a fight, especially between grandparents or between siblings, saying that they're the right person to raise the kids until the age of 18, and having this dispute in front of a judge, which can really lead to a lot of conflict in the family. So having something in place, I would definitely recommend. But I don't know that I would always necessarily recommend sharing it with family members. You could maybe find some nice ways to say, Mom and Dad, I know that you love the kids, and I know that you would do a great job in raising them, but I also understand that your time for raising kids has kind of come and gone, and it's okay. And so I just want you to know that we've chosen primary guardians, um, that are more in their child rearing age, and we would always want you to have a significant part in our kids' lives, and we've made sure to communicate that and share that with our primary guardians. Something like that could kind of help to bridge that gap, to make sure that the grandparents aren't fighting against any types of guardianship nominations, but also that everything is clear in case there are changes in the future. That's a really great question. Let's talk a little bit about the assets, and let's talk about the things that we have. And again, there's a default here in Minnesota. This is actually the default beyond the spouse, that here in Minnesota, the state understands that we want our spouse to receive first. And then it says that we probably want any kids to receive after our spouse receives. That if our spouse has passed away at the same time as us, that maybe then we'd be looking to the kids or to the kids' kids, to our grandkids or to our great grandkids, somewhere in our line of succession anyway, is typically where the state of Minnesota understands that we want our assets to go, which is great. This is actually a pretty common sense thing that yes, we typically want our assets to remain in our line of succession. If it doesn't find a spouse, if it doesn't find any kids, then it goes up to the grandkid, our parents level, and it looks for descendants of our parents. So that's things like maybe our parents are still living, great. Then it would go to them, or brothers and sisters, nieces and nephews, grandnieces and nephews. It even goes beyond that to grandparents and out to aunts and uncles and first cousins once removed. It even goes up to great grandparents and making sure that there's somebody, if there's anybody that we can find in family that things are going to go basically in the family in some way. I see somebody sharing actually here. Taking care of children is most important, but what about pets or perhaps farm livestock? And actually, that's a fantastic question. That there are ways that we can provide for pets or for livestock after we're gone in order to make sure that they're well cared for, and that we can provide assets for them and we can provide a direction on where those beloved members of our family go. But it's really important to do estate planning in order to take care of that and make sure that's taken care of. But back to our conversation here about who's going to receive, there is this succession plan in our family that it would go naturally among our descendants first, then we go to our parents' descendants, our grandparents' descendants, our great grandparents' descendants. But one thing that you might note is that in those intestacy provisions, in those provisions from the state of Minnesota, there is no provision for charity. That there is no provision to say 10% or 20% should go to my church at the time of my death. Or I want 10% to go to the Knights of Columbus since I was a member of the Knights of Columbus. Or to other great Catholic charities that we have, like Pro-Life Across America, Sharing and Caring Hands, St. John Vianney or St. Paul Seminary. There are so many wonderful Catholic churches and so many wonderful Catholic charities that are here in Minnesota that we might want to share our inheritance with or our assets with, in addition to stewarding our assets to our spouse and to our kids to make sure that they're cared for in case anything happens. So if you have any of those types of charitable beneficiary desires, then you really need to have some kind of estate planning in place in order to make sure that those get carried out. The how of the assets or how decisions are going to be made, again, really defaults to court here in Minnesota. And we talked about that, especially in the healthcare realm, but also in the financial realm, that if we can't make decisions about our finances, if we can't make decisions about who's going to pay our bills and make sure that our assets are handled, if we become incapacitated, there's a court process called conservatorship. And after death, when dealing with our assets, when dealing with our things, there's another process called probate. And that's what we're going to talk about here in just a little bit. As you can imagine, court often leads to conflict. In fact, it's kind of set up that way. We have an adversarial court system which pits two parties against each other. So you could imagine, a son in court against a daughter arguing about things like should equal distributions be made, or should we have distributions that favor people who really need the assets more? Or things like, I think that mom should have a feeding tube. And someone else saying, no, I talked to mom about it one time and she said she would never want to have a feeding tube. We need to remove that feeding tube. It leads to these types of conflicts that really could be resolved by you sharing your wishes as opposed to having the fight between people who maybe have heard it secondhand, but more often don't even have that kind of knowledge of the situation. After we pass away, the default of how our assets go is through probate. And things that you need to know about probate. Probate's a process where we submit to the court about how, in order to get a personal representative appointed as an agent to stand in our shoes. And that personal representative's job is to make sure that creditors get paid and that any heirs or devisees ultimately receive the remainder of our assets after those creditors are taken care of. Probate takes a long time in Minnesota. It takes at least 6 months. More often, it takes something like 12 to 18 months. And it's kind of intentional that it takes that long time. For one thing, it's an administrative process, so it's just slow going through the court process. But also there are delays built in for things like time for creditors to come forward and have their claim be heard, and time that certain government agencies need to be notified before you can do things like sell the house. So there are just these delays that are built in that are natural to the probate process, or that are built into the probate process. Probate's also expensive, that we estimate probate to cost something like 3 to 6% of the gross value of a person's estate when they pass away. And just as an example of what that might mean, there are all these different fees that kind of enter into that, things like attorney's fees and filing fees, bond premiums potentially. Sometimes the executor or personal representative wants to collect a fee, things like appraisal fees and creditors, obviously. But just to give you an idea of what 3 to 6% of the gross value of your estate means, for example, if you own a $400,000 home, $12,000 is a 3% estimate of what probate is going to cost for that estate. And that's on the low end, I would say. $12,000 is probably on the low end. Probate is also public. So this is the last will and testament of our president JFK, and we can see in this will exactly what was required and how things were going to be paid. In fact, there's this interesting provision down here that he gave to his wife, Jackie Kennedy, if she survives me, $25,000 and not all of the remainder. If you continue reading in his will, he actually gives her one half of the remainder, um, and not everything, which is really interesting provision that Jackie Kennedy didn't necessarily stand to receive everything from JFK's estate, and probably didn't receive everything from JFK's estate. Instead, JFK actually included his children as one half beneficiaries, or one half of devisees. So I've got son in my face, one half devisees at the time of his death, and they ended up receiving instead. But all of this is public because probate is a public process. But court processes are often public because the government believes that there's value in transparency, and there's value in providing information about how things are being taken care of and how things are going to be administered through the court process, which means that things get filed publicly, including who's going to receive and what amounts they're going to receive. But the good news here, we've talked a lot about court and how it's kind of the default in Minnesota. The good news here is that court is optional, and that there are ways that we can opt out of court. Things like a healthcare directive allow us to opt out of the guardianship court procedure entirely, because we can name an agent to make healthcare decisions for us, to make decisions about our person during our lifetime, including our wishes regarding life-sustaining treatment. And a power of attorney allows us to opt out of the conservatorship court system, because we can name an agent who can pay our bills and handle our finances for us if we become incapacitated. They handle finances, they handle taxes, they handle legal matters. That's the role of the power of attorney, is to handle those things. We can also write a will, but a will doesn't avoid probate. And this might be a surprise to a lot of people here in attendance. In fact, it's usually a surprise when I tell prospective clients or clients. It's usually a surprise when I tell people a will does not avoid probate. A will has to be submitted to the probate court in order to be administered under the provisions, to be interpreted by the court, in order for the person that you're appointing as the personal representative to actually be, and you're actually nominating that person. You're not appointing them. The court is the one who actually appoints them after they approve that nomination that you've made. And so that's a really surprising thing to a lot of people. I see someone asking, does the beneficiary of, for example, life insurance have to go to probate to receive the benefit, or do they receive the benefit easily? And actually, that's a really good question. A beneficiary under beneficiary designation receives the asset directly. And this is really important to know, is that probate is optional. And there are great ways to avoid probate here in Minnesota. One of those ways is what I was just talking about. Through those beneficiary designations, you can even put a beneficiary designation on your home with something called a transfer on death deed. And that's effective to transfer your assets at your or transfer your home at your death to the people that you have listed as the grantee beneficiary. Um, or another fantastic estate planning tool, one that allows for additional customization and some additional control over how things are going to go, is a revocable living trust. So long as that revocable living trust is fully funded, the assets actually get put into that trust. Um, so here's the standard for probate. Probate's required if you have real estate in your name at your death, or if you have more than $75,000 of assets in your name at your death that do not pass by joint ownership or by beneficiary designation. Okay. So that's kind of the definition of probate when probate's required. If you fall under that, then you qualify, then your estate is what's called a small estate. And there's a real abbreviated process that your assets have to go through. It really just involves signing what's called an affidavit for collection of personal property by your representative. It's very simple for them to go and collect your assets. But for most of us, probate is the default way that our estate is going to be handled unless we choose one of these ways to avoid probate. And important to know about a revocable living trust. Again, it's a fantastic tool. It's essentially an agreement that you're creating with somebody called the settlor and the trustee, where you as the settlor transfer your assets to yourself as the trustee. But then if anything happens to you in this agreement, we have a successor trustee listed who can step right into your shoes, doesn't have to go and be appointed by the probate court. They just automatically step into your shoes in order to carry out your wishes under that trust agreement. And it's a really fantastic tool. It's a great tool. When we talk about fully funding the trust, I did this demonstration where I transferred the pen from this hand to this hand. That is really important when we talk about the trust. So with things like your real estate, we transfer your real estate into the trust using a quick claim deed, typically. With things like bank accounts, it takes a trip to the bank where you're actually telling your bank, I no longer want to have this bank account in my personal name. I now want this bank account to be in the name of my trust. The same thing with investment accounts. We're transferring it in title into the name of your trust. With things like retirement accounts and life insurance, those are typically handled by beneficiary designation. And then vehicles typically are, if they have a collective value of less than $75,000, we typically leave those in our clients' names. But that's how you fully fund a revocable living trust. And that's really where a lot of the rubber meets the road and making sure that your estate plan is going to do what you want it to do. All right. Let's talk a little bit about estate taxes. And here I usually get to give people good news. The bad news is that there are estate taxes, that there's a federal estate tax and a Minnesota estate tax. The worst news is that the federal estate tax rate gets up to 40% pretty quickly. So they take a large chunk of the assets that are subject to probate. And that's bad news, obviously. Minnesota also has an estate tax. The estate tax rate here in Minnesota is lower. It's something like 13 to 16%, depending on how high above the exemption amount you are. But the good news is that there are exemption amounts that we get to pass over $13.99 million, up to $13.99 million, tax-free from federal estate tax after we pass away. And here in Minnesota, there's also an exemption amount. It's not as high, but it's still pretty high, and it doesn't apply to most people then. Or the Minnesota state tax doesn't apply to most people. We get to pass $3 million to the people that we love, completely estate tax free, before that estate tax rate kicks in. So estate tax doesn't apply to most people that we talk to in my office. In fact, it's somewhat rare that we hear about people who estate tax applies to. It's not the primary reason that people do estate planning, but it's important to know about. And if it is something that will involve your estate, then you definitely want to reach out to me and we can talk about ways that we can help plan to minimize the amount of estate tax that would have to go to the government. Little caution here. Oftentimes, we can be very charitable and very giving and very thoughtful of people who maybe have some special needs in our family or among our friends and people that we love. And if somebody has some special needs, if they're disabled, and they need some special care in deciding in helping them with where they live, in helping them with food, and helping them with healthcare. A lot of times we can see that and we say, I want to bless this person by leaving some of my inheritance to them to make sure that they're well cared for. But I want to caution you on that because giving an inheritance to somebody who has some special needs like that can actually cause them to be knocked off of any government benefit that they're on until that inheritance is completely spent, which can be really disruptive to that individual. And so there are some great tools that we could look at. These are actually some of the irrevocable trusts that we might look at. I guess they could be written as revocable trusts as well, but oftentimes they're written as irrevocable trusts. A special needs trust or a supplemental needs trust is a way to bless those people with assets without knocking them off of some government benefit that they actually qualify for and that they actually are using. So we've talked about a lot of things today. We've talked about planning for your healthcare. We've talked about planning for your funeral. We've talked about planning for your assets and making sure that your assets go the way that you want and in the manner that you want. We've talked about estate taxes. We've talked a little bit here about special needs planning or supplemental needs planning as well. We've talked about a lot of things. And maybe something has resonated with you here today. Maybe there's something about your estate plan that you want to change. And now you're probably having this thought, is this something that I can do myself, or do I need to hire an attorney like TJ in order to take care of this for me? And I want to caution you against trying to DIY your estate plan. Um, I've I always describe estate planning, DIY estate planning, as putting together IKEA furniture without the instructions. It's really complicated. There are a lot of moving parts. They all need to fit together in exactly the right way. If you don't have somebody who understands it deeply and can look at the big picture and make sure that the pieces are fitting in the right way, you may end up with a mess. I also like to tell a story about a DIY project that I did where I failed in that DIY project. I had purchased some new fishing rods and received the fishing rods, but they didn't have fishing line on them when they got sent to me. So I needed to put fishing line on those rods. And reels, not a problem. I ordered some fishing line and went down to the basement and was winding some fishing line onto those rods and reels. And when I thought that I had enough fishing line on the reels, I went to snip the fishing line at the end. And I don't know what I did exactly to goof this up, but all of a sudden that fishing line started jumping off of the reel, and I had this tangled mess of fishing line on the table in front of me. That was a DIY failure. It was a DIY project failure. I'm not afraid to admit it. But it was a DIY failure with a silver lining. I was able to fix the problem. I was right there. I was able to see that there was a problem. I was able to deal with it right away. I think it probably took me something like 5-10 minutes to get it all cleaned up and to make sure that I still had functioning rods and reels that I could take my kids out fishing with. It maybe cost me something like 30 cents in fishing line that I had to throw away because it was too tangled for me to unravel. But that's not a big deal. Something like 30 cents, I could, that's an okay expense. I probably spend more on fishing line that I get tangled up in weeds and on logs and that kind of thing anyway. It was okay. And like I say, I was able to take care of it myself. I didn't have to wait and rely on somebody else to take care of it. I didn't have to leave it to be somebody else's problem. I bring up all those things because estate planning is the exact opposite of that situation. With estate planning, I can tell you the cost is never going to be something like 30 cents. Cleaning up estate planning messes The costs are always in the hundreds or thousands of dollars. Always. It's always a mess if something gets done accidentally or mistakenly. It's always a mess to try and clean it up. And you're not going to be there to fix the problem. You're going to have to rely on your family to fix the problem, and they're not going to have, if you've done it yourself, they may not have a trusted advisor, a trusted counselor to help guide them through the situation and take care of the problem at that time. Um, and it's not something that's going to be quick to fix. It's not going to take 10 minutes to fix that problem. It's likely going to take months and months, maybe years, to try and get the problem resolved and fixed. And so I don't recommend trying to DIY your estate plan for much the same reason that I don't recommend trying to DIY plumbing that's inside the wall, that you can do a ton of damage to your home if you goof up plumbing that's done inside your wall. And maybe there's some people that could handle it. For me, I don't do it, and I make sure to hire a professional in order to get it done. I see somebody here saying a friend used a lawyer and still ended up in a nightmare when they died. How do I avoid this? And that's a fantastic question. Choosing an attorney is really important as well. There's the typical experience, and then there's the experience of planning with an estate planning professional like myself. With a typical estate planning experience, a lot of estate planning attorneys out there, they're just going to use form documents. They're going to be kind of set it and forget it. Um, it may avoid probate, but it may not. It may keep your money out of the Minnesota Department of Unclaimed Property. That's something we didn't really talk about tonight, but there's over $700 million in the Minnesota Department of Unclaimed Property because assets get lost when people pass away. And so that's a typical estate planning experience isn't even going to take that into consideration. Typical experience probably doesn't keep your family out of conflict. In fact, it might opt into the probate process. It might opt into some conflict when a typical estate planning attorney takes care of things. It may leave the assets to heirs unprotected in a way where the assets are either going outright to them at too young of an age or without asset protection to make sure that those assets are reserved for those heirs, for those devisees that you want to receive. It's not going to include ongoing legal guidance because the typical estate planning experience typically is based on hourly fees, which is a really opaque and outdated way of handling estate planning and estate planning fees. But it's going to require hourly fees into the future, which means you're not going to want to reach out to that attorney to ask them questions about your estate plan. And it's not going to adequately protect your kids if something would happen to you. It's going to leave you with this question. Is my estate plan going to work when I need it to work? And that's not a question that you should ever have after you've worked with a professional. You should never question, is this going to work the way that I want it to? You should be educated and empowered to know that your estate plan is going to work the way that you want it to. And that's what it's like when you plan with me. When you write a plan with me, I charge flat fees and you actually choose the fee package that fits you, your finances, and your family the best. We help to make sure that the money stays out of the hands of the state. We make sure to protect your kids totally, both in the immediate, short term, and in the long term. We make sure that your family stays out of court and conflict. And that really is at the heart of why I started my own estate planning law firm. At my core, I'm a peacemaker and I believe in keeping peace in the family and keeping the family intact. And I've seen the way that families can get torn apart when estate plans aren't written the right way, and they're not carried out the right way. And so making sure that your family avoids court and conflict is something that's really at the heart of the way that I practice. Planning with me means that you're going to know that you've made the right decisions. We spend a lot of time and energy educating our clients because we know that they need to have the information about the laws. They need to have the information about exactly what the different estate planning tools are and how they operate together in order to empower them to make those decisions for themselves and for their family so that things are going to go the way that they want them to. Planning with me means protecting family money from outsiders through things like asset protection, but also through things like making sure that the kids don't receive at such a young age that they're going to be vulnerable and use that money or be vulnerable to attack from someone outside that would prey on them if they've received a large inheritance. Planning with me means a lifetime of guidance and protection. Included in the flat fees that we charge is ongoing communication about your estate plan. That we are here as a resource for you to ask your questions and get answers about your estate planning, including things like, does my estate plan need to be updated now that my first grandchild has been born? We've done a lot of estate plan reviews, complimentary for clients, to assure them that their estate plan is still doing exactly what they want it to do. And we're able to do that because we roll in that future guidance and protection to the flat fees that we charge. You're going to know after you've worked with us that your estate plan is going to work when your family needs it to work. And that assurance, that comfort of knowing that things are going to go the way that you want it to is a huge thing. When you choose an attorney, you want to make sure that it's somebody who has your same values in mind. I went ahead and shared a link in the chat to my calendar, and we keep that calendar updated. I want you to click through and look at the family wealth planning sessions that we offer. And I'll tell you more about that family wealth planning session in just a minute, but I just want to make sure I've put that link out there. And my guess is with as many people as we have on our call here tonight, I think probably that's going to be, that's going to be used pretty quickly. And I want to encourage you to take a look and make sure that you have time to reserve a spot if you want to reserve a spot with me. But when you choose an attorney, you want to work with somebody who has a proven record of taking care of people, and also that shares your values. Like I say, I am Catholic. I'm actually an alumnus of St. John Vianney Seminary. I discerned priesthood there for a year and a half when I first graduated from high school. You've probably or you possibly seen my advertising in Minnesota Catholic. We're very involved with giving to Catholic charities and Catholic interests throughout the Twin Cities. And we are sponsors of the St. Joseph's Business Guild as well, a Catholic group of business owners and employees. And so we certainly share your values and want to take care of you. And we want to offer you some special gifts for being here with us tonight. And one of those gifts is a free family wealth planning session with me to talk about the things you have and the people that you love and how you can protect them. And I've spoken generally here tonight. I've been able to address a few questions, but that family wealth planning session, it's a free session. It has a $750 value because it's a 2 hour long session with me to talk about the things you have and the people that you love and get really specific about different estate planning tools that we might use to help you to plan your estate and different considerations that you might want to make as you are looking to plan your estate. But it is completely complimentary. There's no obligation to continue to write an estate plan for us, but it's a great opportunity to get specific information for you and for your situation. The other thing that I want to give you is $250 towards the estate planning package of your choice. That if you do decide to write an estate plan with me, great. I would love to help you with writing your estate plan. But if you want to write that estate plan with me, I want to give you $250 off the package of your choice if you will reserve your family wealth planning session before the end of the week. And I'll tell you, if you've clicked through to see the appointments that I have available, you've probably seen I don't have any appointments that are available here this week. What I'm saying is not that you have to have that family wealth planning session with me before the end of the week, just that you have to reserve it. If you click through the link, my guess is that probably a lot of my availability actually is out into June, into July. And there's a reason for that, that I only take on a certain number of clients in any given month. That's kind of a limited number of clients. And I do that in order to make sure that I have enough time and attention to give each client to make sure that they know exactly that they have the education and empowerment to make sure that their estate plan is going to work the way that they want to. But it requires time and it requires attention in order to take care of my clients that way. So go ahead and click through to that link. The family wealth planning session, let me tell you a little bit about the family wealth planning session before I answer some questions. This is a really good time if you have some questions. And I do see a question here from Katie that I'm going to get to here in just a minute. But this is a good time to ask questions. The family wealth planning session is a 2 hour long session. In the first part of the session, we talk about what your current estate plan is. If you've written an estate plan, great. If you haven't written an estate plan, then we talk about what the state of Minnesota's estate plan would mean for your assets and for the people that you love. We talk about who would make healthcare decisions for you if you couldn't make them for yourself. We talk about who would make financial decisions and handle paying your creditors if you couldn't make sure those creditors were paid. We talk about what would happen after you pass away. How would people receive? Who would receive? And what would they receive? And what would the timeline be? What would it look like? What process or procedure would they have to go through in order to receive? We talk about all those things and share information about the law with you. And we also ask you questions about your family and about the things that you have, because we might know a lot about the law, but we don't have that information about your family and your family dynamics. We don't have that information about your assets unless you share it with us. And so you're really the experts there, and we're going to rely on you. We're going to look to you to share that information with us and help us so that we know exactly what we need to know in order to help you plan your estate. But we're really doing a lot of educating in that first hour to make sure that you know what the current reality is and what your options are to take control and to make your wishes what you want them to be. After that first hour, there's an opportunity then to hire us if you want to hire us as your estate planning attorneys. If there are certain tools that we're offering that you think would be useful, and if you trust us to help you put those tools into place, to implement those tools, we would love it if you would hire us and make us your estate planning law firm and me your estate planning attorney. Absolutely would love it. And if you choose to hire us, then we can continue into the second hour of our conversation in that family wealth planning session, which is really designing your estate planning tools that we've talked about and making sure that we have them written in the way that you want them to be written. We're not going to sign anything in that first meeting, but it's really where we're putting all the elements together. After our first meeting together, after that 2 hour long meeting, we will follow up with you in order to confirm the elections that you've made and to confirm information about the people that we want to have involved in your estate plan. We may confirm some information about your assets as well. And then we will get back together in about 4 to 6 weeks after that first meeting, where we'll actually have your documents ready for you to sign. And that's the date, 4 to 6 weeks after your family wealth planning session, where everything will be effective and you will have a fully written estate plan. And I see my friend Joan saying TJ's been easy to work with. That means a lot, Joan, and we've definitely enjoyed working with you. So I do have a question here that I want to address as well, and I apologize, Katie, that's taken me a little while to get to your question. But it's, if I complete an estate plan in one state but then move to another state, do I need to make a new estate plan in the new state? And the answer to that is typically you do want to have your estate plan reviewed in that new state. And the reason is that estate planning law and probate law is state dependent, and it's written, depending on and what state you're living in, there are different laws that are going to govern how things happen. However, there's typically estate planning reciprocity, which means that if you write your estate plan here in Minnesota and then you move to Wisconsin or you move to North Dakota or you move to, any other state, typically that state will apply your estate planning documents as long as they were correctly executed here in Minnesota. And so it really becomes a question of what does the future hold for you? That if you have a plan to move within a year, I would typically counsel you to consider whether it's best to write that estate plan right now. It's all a matter of risk, right? What risk are you willing to endure not having an estate plan in place? If something happened to you in the next year, 2 years, 3 years, what would that look like, and what would be the repercussions of that? Um, a lot of times people will tell me we have a plan to move out of state, but it's an indefinite plan, and we don't know exactly when that's going to happen. Typically, when that's the case for people, I do encourage them to move forward and write an estate plan. With those types of indefinite plans, the risks of not having an estate plan in place are pretty high, and we want to make sure that you have some kind of an estate plan, so that if, in the unlikely event that something does happen to you, your family isn't left with a mess. And there would be some additional costs probably in updating your estate plan in a different state. But that risk mitigation, especially with an indefinite plan to move to another state, we typically recommend, take the time, write an estate plan, invest a little bit in that estate plan so that you know that your loved ones are taken care of, that your assets are taken care of if anything happens to you. I'm not seeing other questions coming in, but I'm watching for them. So please share with me if you have other questions. I often get questions about things like real estate and how do we plan for real estate. There are estate planning tools like transfer on death deeds, but oftentimes a living trust or a revocable living trust can be a great tool to plan your estate because it allows us so much ability to tailor exactly what you want to have happen with your assets after you're gone. That you're able to direct your assets specifically to people and in specific ways to make sure that they are able to receive. A transfer on death deed is going to automatically transfer ownership in your house after the surviving owner passes away directly and without any control. And so, if you try and list on a transfer on death deed a minor child, it's going to lead to disaster, to problems. Or if you have a transfer on death deed to more than two kids, I often tell people, the possibility of conflict, the possibility of arguments between more than two kids is pretty high, and we typically want to name one individual to make decisions about how the house is going to be handled. And the best way to do that is by naming a successor trustee in a living trust or in a revocable trust, as opposed to making three or more people equal owners in a house. Because I've heard that situation, I've heard how it can go wrong. There is a process called a forced sale, but if you want to avoid conflict in your family, having one of four owners in a house try to force sell the house out from the other three is a way to guarantee that there's going to be long lasting and probably irreconcilable conflict in the family. I see someone asking here, do you offer advice on taking assets out while still living, for example, 401k post-retirement? It's a really good question. It's not typically guidance that I do. Typically, you would look to somebody like a financial planner for that guidance, but I do sometimes make some recommendations based on what I'm seeing with your assets, some recommendations on things like talking to your financial planner about a Roth conversion. And a Roth conversion can be a great way of planning for a lot of tax qualified money, either when you're close to retirement or just after you've retired. Typically when your income is at its lowest level, that we want to look at Roth conversions as a way to potentially take tax qualified money and turn it into non-tax qualified money, but in something like a Roth IRA where it can continue to grow tax free. It just means that you can also take it out tax free in the future, which can be a real cost savings. I see somebody asking me here, I'm not determined who I would want as power of attorney or as executor of my estate or where I want funds dispersed. Do I need this done before scheduling the 1 hour meeting? This may take some time. That's a really good question. I would encourage you to get that meeting with me. I would encourage you to still sign up for that family wealth planning session with me, and bring some options to talk about when we meet together. But a lot of times we're able to explore options and discuss things and discuss different ways that you might want it to be handled, which may open up some considerations that maybe you didn't have, or maybe you wouldn't have had, unless we had our conversation. And so I really, like I say, I really recommend that you still schedule that meeting with me come in and have the conversation, bring some options, but also be prepared to talk about some other options as well that we often uh, like to explore those and brainstorm a little bit. We typically want to walk out of the family wealth planning session with everything down on paper, at least in pencil. Okay. And that's kind of a rule that we have is at least if we get some fundamentals down on paper in pencil, we can always adjust those things later on. But having it in pencil allows us to think about it and to see, to at least sleep on it and see if this is maybe the way that we want things to be handled. So that would be my recommendation. Do still to still sign up for the family wealth planning session. I'm going to go ahead and post that link one more time. I really encourage you to click through and find some time right now. Just do it now. And the reason that I recommend doing it now is because we all get so busy in our lives. And I completely understand, as again, a father of five, as an owner of my own business, I completely understand that we get busy and time gets away from us. We prioritize different things on our to-do list, but this is a priority, and making sure that you get your estate plan written for the people that you love, that you live up to your promise to take care of it, is something really important, really fundamental and foundational right now that you need to get taken care of. And you can take care of it. Just do the next best step. And the next best step is booking your free family wealth planning session right now. Go ahead and book it, even if we need to adjust the date, after our call here today. If you need to call my office tomorrow or later this week, I would rather that you have some time reserved on my calendar right now so that you know that there's going to be time reserved on my calendar. And you've taken the next step. You have that next step on your to-do list already checked off, than waiting and saying, I will get to it. I'll get to it probably on Friday or Saturday. The number of times that I see people take that approach and Friday or Saturday comes and there are other priorities that have moved up the to-do list. And so you don't get the meeting scheduled. And now, we're into next week and all of a sudden you're saying, I wonder if TJ would still give us the $250. I don't know. Maybe I wait and see if I can catch another webinar of his in the future. Don't don't do that. Don't worry about that. Just get on my calendar now. We can adjust it. You can call in and talk to me if we need to adjust the appointment. But I really want you to take advantage of these offers. The reason that I offer $250 is to make it easy for you to take the next step. I want you to take that next step and make sure that you have your time reserved so that we take care of things for you. And we can make it so simple. We can make it so easy. And I really appreciate Joan sharing her experience a little bit, that we really can make it easy and take care of things for you, while also making sure that you're fully educated and fully empowered on your estate plan to make the decisions that make the most sense for you, for your assets, and for your family. I'm not seeing any other questions coming in here. But I will take just a couple more minutes to make sure that if people have extra questions, that they're able to get them answered. All right. All right. Well, I'm not seeing not seeing any other questions come through, and that's great. Maybe I was that thorough. We can all dream, right? Thank you everybody for joining me here tonight to learn about estate planning, and especially to learn about estate planning in some specifics that are especially important for Catholics to know. I really appreciate you being here with me and giving me your time. It's been great to share this time with you. I do see a question coming in on suggestions for donations of assets. I'm pretty partial to St. John Vianney Seminary as a good Catholic charity here in Minnesota. But again, there are other great ones. Pro-Life Across America is a fantastic charity. Sharing and Caring Hands is a fantastic charity. Giving to your church, giving to your faith community is really important to do in order to make sure that they're able to continue things going is also really important. So there are lots of really good options as far as donations, come in and meet with us, and we'll talk about your priorities and what's important to you, and talk about other places that you can donate your assets if you're looking for options. Then I have a question here, stepchild versus my child. And that's a really complicated situation. It's really dependent on family dynamics and how you want things to go. That oftentimes, the the default here in Minnesota and the default for most people is that stepkids wouldn't be included, that it would only be naturally born children or adopted children that would be included in the estate plan, would be included in inheritance and um, who's going to receive from your estate. But it doesn't have to be that way. That things can be handled in whatever way you want it to be handled. And so the real key there is making sure that you take control and write the estate plan in the way that you want it to be written. And that's really the important thing. That's a great question. Seeing lots of thanks for being here. That's fantastic. As far as I also see a question here, how much financial information do I need to bring to a meeting? Do I need statements, certificates, etc., value of estate? That's a really good question. We actually have a form that we'll send out before you come in and meet with us. It's an online form, and we just encourage you to do your best to share the information on that form with us. It'll include information about your family, information about your assets, but it doesn't have to be perfect. I think on that form, we ask for things like account numbers. You don't have to share account numbers with us. You don't have to share social security numbers with us, even though I think we ask for it. Those options are there if you want to go in and include that information in the future. It's kind of a portal that you can go through that will always keep that information secure for you, so that if something happens to you, we can go back and access that information and make sure that things are taken care of. But we really encourage you to fill out that form, to give us some information. It makes our meeting much more effective if we have some information and details to work from. And then I have a 24-year-old daughter with a new spouse marrying next year. I believe you said the estate usually has things go to the spouse first and then kids. And so typically what would happen, and what I was referring to there, is your 24-year-old daughter would be the natural recipient of your estate. And typically the new spouse that she's marrying next year, or maybe it's your new spouse that you're marrying next year. Actually, that's a really good question. Um, yeah, you're getting married. Sorry, I see that now. Okay. So you have a 24-year-old daughter and you're getting married next year. And so the answer is it's complicated. And there's a certain amount that a spouse can elect to receive after their spouse passes away. That the state of Minnesota wants to make sure that we're caring for our spouse if anything happens to us. But that typically, if there are children who are not joint, who are not shared between both the spouses, typically there's something that's going to those children as well. And you can detail that more. You can take control of that and detail that more by writing your estate plan, exactly what you want to have go to your spouse versus what you want to have go to your daughter. And my condolences. It says you say her father passed away. My condolences on losing that important person in her life and in your life. I can't find how to sign up. I found the 20-minute meeting or the 120-minute. Do you work with elderly with no family? So yes, absolutely. I work with elderly with no family. If you click on the link, you should see the 120-minute meeting is the meeting that I'm talking about. It says Family Wealth Planning Session, and if you click into that, you'll see it doesn't look like there's any more time available right now in May, but we do have some availability. Actually, there's pretty good availability yet in June, some good availability in July and August. So if you click on the arrow up at the top of the calendar, you should see some good time available to meet with me still in June or July. That's a good question, and hopefully that comes through for you. Hopefully you can see how that works. And I'll hang out here for just a minute. Donation could be feed my starving children, just an idea. That's a great suggestion. That is a great suggestion as well. Well, this has been fantastic. I really appreciate the attendance. I really appreciate you pitching in with your ideas and sharing information with me. Thank you for being here tonight. Again, my name is TJ Scott. I'm a Minnesota estate planning attorney. I've really enjoyed spending this time with you and getting to present with you. I hope that you will reach out to me. I hope that we have an opportunity to meet in the future and discuss your particular situation together. And I hope that you all have a great night. Take care.